she went to Facebook and tried to put out sort of an Amber Alert. We can't be calling law enforcement and CPS at the drop of every hat.
It appears, on behalf of the defendant, Gregory Wolf, Attorney Carolyn Gaston. Ms. Gaston, good morning.
Good morning, Your Honor.
I have read your motion, Ms. Gaston. Is there anything you'd like to add to it before we hear from Ms. Mahoney?
Just briefly, Your Honor, as you may recall, we were here on March 28th of 2025 on an initial motion. The ruling following that motion was to follow the status quo, but that if we were unable to resolve the issues, to come back to you and you would, I don't know, do something, send it to the front of the court, whatever. Since that time, there have been a total of 15 police reports obtained between 2022 and January of 2025. I believe there are more out there now, but my FOIA request obviously was only through the date that I asked for it. So we've had to re-FOIA. The parties had entered into some temporary agreements, which were to include parenting time beginning for my client on the 4th of July. On the 5th of July, Ms. Ray, as I hope the court has read, contacted the police wanting to know where the child was during my client's parenting time, because he was at a park and during his 4th of July celebration on the 5th with the child. And when the police wouldn't help her, she went to Facebook and tried to put out sort of an Amber Alert. Subsequent to that, Your Honor, which you may have gleaned from the response, the plaintiff was hospitalized at Pine Rest due to mental health issues, and she was there from July 8th to July 16th. I did not receive the records from Pine Rest until July 24th, and Ms. Ray now wishes to return to this Thursday through Monday morning parenting time that had been put in place because, as you know, the paper does not reflect that my client had custody and he had relented at some point towards the beginning of her filings to this Thursday through Monday morning parenting time. And that's every week. He also has Fridays off, and he also is off on weekends. So we've been angling to go to an every other weekend type schedule, but now we're very concerned about the safety of the child in Ms. Ray's care. And so my client is really seeking supervised parenting time pending some stabilization period. The medical reports say that she appeared stable upon release, but then the pleading indicates that she was already in med reviews with monitoring medication. So this is not a new mental health disorder. It may be contributing to all of these police activities that we've discussed in the pleading. And I didn't attach all of them because it would have been voluminous. But essentially, that's our request, Your Honor, and that we either get an immediate evidentiary hearing or go to the front of the court. Ms. Ray seeks full custody, just a return to as if there never was a 3-year lapse in parenting. So that's why we're unlikely to resolve it in mediation, which was scheduled, so the court knows. It's just that Ms. Ray had this mental health breakdown and we weren't able to, accomplish the mediation and felt like we needed to get here sooner rather than later. Thank you.
Thank you. Before I turn to Ms. Mahoney, my information indicates that someone, I understand why mediation was canceled. It's doesn't make me particularly happy, but I understand. But what I'm getting word is that mediation was canceled because someone said it was inappropriate to mediate. Do you know who said that, Ms. Gaston?
I do not, Your Honor.
Okay. All right. And you would agree with me, from my review of the record, an ex parte motion was denied by Judge Gottlieb on July 11th of 2025. Is that accurate?
It is accurate, and what's strange about that is the order itself says, you know, CPS should be the ones to get involved here. Both parties have called CPS. CPS has been to my client's home many times and not substantiated any of the claims. If we can't be calling law enforcement and CPS at the drop of every hat, so we need to resolve this in a timely fashion. I forgot to comment, Your Honor, that I have had an opportunity to review the Sims v. Verbrugge case, and that's a 2017 Michigan Court of Appeals published decision. I don't think my client needs to reach that threshold on the issue of joint legal custody, and I certainly think that he has reached the threshold, so to speak, on physical custody, given that they weren't operating under the then existing order.
Thank you. Ms. Mahoney.
Well, Your Honor, I think I'll kick off with the easy thing. First off, Ms. DeHaan indicated that she has no objection with this going to front of the court, and she in fact thinks it would be helpful. I'll note that Ms. Gaston said that mediation would be canceled because of my client's hospitalization. While our client was hospitalized at the time, it was my understanding that there were emails from both parties or both attorneys back and forth indicating a desire to reschedule mediation even before this hospitalization. So I think that to characterize it as completely being because of my client's health care is a little bit inaccurate. I think that the issue was that the parties were kind of feeling that front of the court may be a better route to go, and they were discussing an agreement to move the mediation. And then ultimately, my client's health issues kind of did factor in because it overlapped with the same date. But I don't think that this was a situation where that should be solely put on Miss Ray. As far as the issues with supervised parenting time, I'd first note, you know, much is made of these police reports, Your Honor, from 22, but I would note that a lot of them were from 2022, 2023. The orders that are in place now clearly reflect that this parenting time arrangement was based on a status quo with the parties. So even with this police activity, I know he's saying that he just found out about the police reports, but essentially he's acknowledging that during that entire time, she had this parenting time. There were no concerns. Ms. Gaston even noted that CPS has not substantiated any concerns. As far as the allegations that are more recent in the ex parte, I mean, certainly we would acknowledge that that Facebook post was not appropriate, and I think my client is prepared to acknowledge that. But I think the issue was that she was going through a medication adjustment. That had to be done slowly, and ultimately she needed more help than what that slow increase in medications could give her, and that's why she was hospitalized at Pine Rest. I have a letter from her physician that indicates that she was admitted on the Aspen unit from 7/8 until 7/16, initially presenting with concerns of paranoia and difficulty taking care of herself. She was then started on medications, was provided with various group therapies. She did well in the unit and responded to medications. She showed significant improvement and appeared stable at the time of discharge. My client is now continuing to take care of her mental health. I would note that there are no allegations in the ex parte order or otherwise that she ever posed a threat to the minor child. She was not threatening his safety. Her hospitalization occurred while he was with his father. And I think that this is a situation where she had an isolated health event. It's connected to that Facebook post, but that isolated health event is currently being treated. And at no point is there any indication that she was treated for a suicide attempt. At no point is there any indication that she posed any threat to Theo. I'd note, Your Honor, you already raised the fact that this ex parte was denied. That letter from Pine Rest was provided to Ms. Gaston, and at this point it's been indicated that Mr. Wolf does not want to return to the parenting time until you weigh in. I think it's a little interesting that the position here is that the concern is that my client won't return the child during parenting time, but in fact, right now, she's the one who's been denied parenting time. And I know Ms. DeHaan has been trying to be respectful of that, given some of the allegations here, but ultimately, Miss Ray was following the orders, and Mr. Wolf now has decided that he's not going to agree to any parenting time unless and until you order it. I think at this point, Your Honor, given the situation, given the fact that her mental health is stabilized, that she was never an imminent, she never posed any threat to the child. There's no CPS involvement. I think it's appropriate for the court to go ahead and resume the current schedule, which is reflective of the status quo that the child is familiar with. And from there, schedule us for hopefully an FOC investigation and then ultimately an evidentiary hearing on the broader issues. But I just don't think that there are any indications that it would be harmful to the minor child to switch it up from what the parties have done and what the child knows. Thank you.
Thank you. Ms. Mahoney, who is Malachi?
That, I believe, is my client's former partner. I know Ms. DeHaan indicated in her response that there was a domestic violence incident in January. My understanding is that they have separated. She is working with Safe Haven. She is not in an ongoing relationship with that person at this time.
Thank you. Ms. Gaston, I'll give you the last word.
Thank you. With regard to Malachi, Your Honor, he's been an on and off boyfriend for several years, and many of the police reports involve him. They did not separate in January. They may have separated in June. That's my understanding from opposing counsel. I don't have any documents, and we don't know a date, and we don't know what happened that ultimately resulted in the separation. The child has been exposed to many of these incidents, and that's what's reflected in the police reports. I'm not certain what would have happened to the child had he been present during her mental health breakdown. I have indicated that there was some rude behavior on the part of Ms. Ray towards the child during a ice cream incident with Malachi, which she has denied. I do think there are dangers. And with regard to any denial of parenting time, Ms. DeHaan and I had discussed that once I had the records that we would revisit what we would do with parenting time. I didn't get the records from the actually, they're not directly from Pine Rest. They're what Ms. Ray provided, except for the letter sent until the 24th. So if there's been any denial of parenting time, it would have started last night, Your Honor, and we thought we were headed here today. It just made prudent sense to take this matter before the court, because ultimately the court is the truer fact in this particular situation.
Thank you both very much. Let me first say that I appreciated the submissions by both parties. I thought they were well written and very clear. As both you, Ms. Gaston, and you, Ms. Mahoney, know, the Board of Appeals is rather cranky when it comes to changing things up on a Friday morning without an evidentiary hearing. The latest case of Beretta versus Zitoff, 348 Michigan Appeal, 539, a 2023 case. There's also a 2025 unpublished case of Kleinfeld versus Stern. That is also suggestive of, even though I certainly am concerned about some of the behavior going on here, I don't have the docket space to tee up an evidentiary hearing that fast. I wish I did. But what I am going to do is this, because Ms. Gaston correctly framed the issue, is we were going to give mediation a shot. If it worked, it worked. If it didn't, then the parties would come back here and I would rule on threshold. The first thing I'm going to do is find that proper cause or change of circumstances has been shown relative to physical custody, child support, and parenting time. pursuant to Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case. I find that the issues of domestic violence, the issues of the possible mental and physical health of the parties involved are directly implicated. Best interest factors found in MCL 722.23, that would be item K and item G. So what I am going to do, I will also tell you that my reading of Sims versus Verbrugge is spot on with Ms. Gaston's 322 Michigan Appeal 205. And that case basically said if there hasn't been a judicial determination of the issue of legal custody, then there is no necessity for showing change of circumstance. So I will refer all those issues out to the friend of the court for an investigation and recommendation. As I typically do, when I have legal aid on one side, I typically waive the fees for both because I think that's only fair. So I will waive the fees for both. I'm also going to direct that a psychological exam be performed on the plaintiff. Some of the things that I've read in there, while not causing me enough to jump into clear and convincing evidence to suspend things, they're concerning. Obviously, I know that Ms. Mahoney and I agree that was wildly inappropriate to do that on a Facebook post. And I want to see what's going on. So I'm going to order a psychological. I have not seen any evidence to suggest that Mr. Wolf would need that same type of treatment. I am going to reserve any tinkering with the parenting time schedule. I want to see how things go in this next few months or month. And if things somehow get really concerning, then you certainly can bring that back, Ms. Gaston, by way of ex parte order for Judge Gottlieb or on my motion day. And hopefully we'll see if we'll take her current psychologist at her word, or at his word, I'm sorry, that things have seemed to be stabilized. But I will do the order of reference myself this morning. But if you could, Ms. Gaston, prepare a separate order requiring psychologicals by plaintiff, and this court is going to order that there be no contact between this individual, Malachi, and the minor child, period. End of story, full stop. We will take care of that issue as well. Ms. Gaston, any questions on what I need the order to say?
I don't believe so, Your Honor.
Thank you very much. Ms. Mahoney, anything further from you?
I guess, Your Honor, I know this is probably not likely to be granted, but given the extreme cost of a psych eval, I'm just wondering if there's any possibility to just reserve on that issue pending the FOC investigation. I know that that can often be prohibitively expensive for legal aid clients, and I'm wondering if FOC, upon the opportunity to review her medical records, may have a different take on this.
Well, I tell you what I'm going to do. I have resisted saying a psychological at a certain place because obviously, Ms. Gaston may, based on what she reviews, may consider that her treating psychologist is okay for this. But maybe she won't, I don't know, because I don't think she's seen all of the records yet. But I will reserve that, Ms. Mahoney. I'm not trying to put anybody into bankruptcy court, but I need a psychological that ferrets out why some of these concerning behaviors are happening.
Thank you.
If you
Your
could,
Honor, in that regard, I don't have a release, and I wonder if the court would grant me a release of her record. Otherwise, I won't be able to review them. And secondly, at the moment, my client pays child support based on a 50-50 custody schedule. So I wonder if the court would suspend support on his behalf. Thank you.
support should be calculated on actual overnights. I mean, if it's not 50-50 right now, then it should be calculated on the overnights using the figures they already have. As far as obviously the what was the first issue you brought to my attention, Ms. Gaston?
A release for the psychological record.
Well, obviously, the plaintiff's mental state is very much an issue in this case, Ms. Mahoney. So I will direct that she sign all appropriate releases so that Ms. Gaston can get the information from whomever she's treating with, because quite frankly, that may, after reading those, she may say, okay, we can go with this psychologist. Maybe, maybe not, I don't know, but I'll direct that be signed within 14 days. If you could put that in the order.
I'm just wondering, because I know that appropriate might be subject. I assume that would be subject to the ability to Ms. Gaston and Ms. DeHaan if they have a disagreement on what is an appropriate range or sphere of the releases, that they can come back to you for clarification if necessary.
If they need a protective order, then that's fine. But normally what I ask of attorneys is that these records not be disseminated to their clients. And attorneys are usually pretty good about that. So that kind of takes the thing out of the protective order. But see if we can get this case back on straight and narrow. Thank you both very much, Ms. Gaston, Ms. Mahoney, for subbing in, and we're adjourned on that matter.
Thank you.